Well, hello out there. Welcome to Boomer Time. As you know, I'm your host, Nancy Cogar, and I am your trusted guide to aging well and preparing for the future. At least that's what I'm trying to do here. And today we are talking about a crucial topic: Medicare, Medicaid, and how they fit into estate planning, important differences between the two. It can be confusing, and they are both very different. Whether you're navigating your own healthcare needs or helping a loved one, today's episode is packed with information that can really make a real difference in managing long-term care and in protecting your assets. If you're an older adult concerned about protecting your assets or the adult child of an aging parent, understanding the Medicaid 5-year look-back period is really key to planning for the future. It comes up a lot when I'm in strategy sessions, and in this episode, we'll dive into this rule. I'm going to share several examples and give you recommendations on how to best prepare. And with this caveat, of course, the 5-year look back always and only applies to any kind of application that you might make for Medicaid benefits. Here in Tennessee, that's TennCare. Those types of benefits are income-based as far as eligibility, and they can only be used when it comes to nursing home care. So a lot of times I just like to look at long-term planning and trying to come up with options to nursing home care. I just thought that was important to mention. So we're also going to discuss some of the strategies, like I said, that can help you avoid the consequences of that 5-year look back. It happens, including using Medicaid asset protection trusts and something known as a Miller Trust. Plus, we'll talk about an alternative strategy for individuals who prefer to retain control over their assets with a Revocable Living Trust. I actually find most people like to opt for that, and we'll talk a little bit more about that. So let's start today by revisiting the basics of Medicaid. Remember, Medicaid is different than Medicare. If your aging parent needs long-term care, like help with daily activities or has a stay in a nursing home, Medicaid may be available to help with the costs of that care. I emphasize maybe because, as I said, it is income eligibility based. And before you can qualify for Medicaid, you have to make and meet certain eligibility requirements. Like I said, that's income and assets, plain and simple. It goes up a little bit every year, but here we're into 2025, and the current income limit here in Tennessee is just under $3,000 a month. More specifically, $2,901. That is the limit of income that you can have in order to qualify, but it doesn't take into account assets, of course. Step one for qualifying for Medicaid is having that monthly income lower than that amount. And as I said, that's not all. This is where that 5-year look-back period comes into play. Medicaid has a rule that says it will look at any asset transfers made in the last 5 years before you make an application for assistance. What do I mean by that? Well, the standard example, and one of the worst case scenarios that we see that leads to trouble, is quit claiming the family home away to your kids for nothing. That is a big problem. Let's say your parents gave away any significant assets and sold the property for less than its value, or transferred assets to someone else during that time. Medicaid can, and often does, penalize people for those kinds of transfers. The penalty usually means a delay in eligibility for Medicaid assistance. So I think it's helpful to break that down with some more real-world examples of what the 5-year look-back period might look like and what kind of penalties you might see. More on that. We're going to take a quick break, but When I come back, we'll talk about those stories. Well, welcome back. We are talking Medicaid and the 5-year look back. What is it? How do you prepare for it? Why and what are the biggest don'ts that might lead to penalties or an outright finding that your parent is ineligible for that kind of help under Medicaid? Well, I said I was going to go over some real world examples of circumstances that might lead to either ineligibility or a penalty period. So here's the first example. And I kind of mentioned this earlier about the quitclaim deed. Well, this is the house transfer. Let's say your father, Jim, is 80 years old and he's been living in the same family home for decades. Mom died before him and Jim's in good health, but, has recently been diagnosed with early stage dementia. Happens all the time. So you're one of his adult children and you've agreed to act as his caregiver. So you're starting to look at what that might look like. And the duties will include helping dad manage his finances. And as part of that, you decide to resolve, the biggest elephant in the room. Let's get rid of the house. That's the most valuable thing he owns, right? And it's paid off, has been paid off for years. You decide, along with your dad's consent, I hope, that your dad should transfer the house to your brother and yourself. That way, we're avoiding future estate taxes, and it's no longer in his name, right? So dad agrees because the house will eventually go to you all anyway, and he transfers the home, thinking it's a good way to protect the property, and it still gives him the right to continue to live there. Well, here's the problem, okay? Fast forward 2 years, and dad has declined further. He's no longer able to safely live at home and needs long-term care in a nursing home. Medicaid is the only way to cover those expenses, and they are high. So here's the problem. Remember, Jim transferred his home to his children just 2 years ago, and Medicaid considers this a disqualifying transfer. This means that Jim may face, and likely will face, a penalty where he will be ineligible for Medicaid benefits. The penalty could last several years, several months. There's still 3 years before a 5-year period goes by. So depending on the value of the house and the cost of care, it may add up to a significant amount of money. So here's the kicker. Medicaid does not care that Jim's children were the recipients of the house. The transfer is considered a gift. Sometimes it's considered a fraudulent transfer. And because it just occurred within the 5-year look back, it affects Medicaid eligibility. So here's another one. How about gifting money to family members? I see that a lot. The IRS, lets you do this without any kind of penalty every year up to a certain amount, right? 2025, that amount is now $18,000. That's a lot of money, and that could really help your family members or grandkids or anything like that. So it's a good strategy in a lot of circumstances. So let's consider Martha, okay? Martha's 70 years old, and she's got a savings account with $100,000 in it. She's always been generous with her family, especially, as I said, her grandkids, and has given them money for special occasions over the years. So at the same time, Martha begins to experience some mobility issues, getting around. She's not able to get around as well. And she realizes, hey, I may need long-term care in the future. So in what she thinks is preparation for that, she decides to give away a significant portion of her savings, $50,000, to her grandchildren in $18,000 increments. She figures this will help them with their education and future. But now, when Martha applies for Medicaid in the future, Medicaid will review the last 5 years of her financial history, including the $50,000 in gifts. Since Martha made this transfer within the 5-year window, Medicaid will impose a penalty period. This means Martha won't qualify for Medicaid right away. That penalty is based on the total amount of the gift, right? And the cost of the nursing home care in her state. And, it's not to mention whether she's eligible based on her income anyway. So if the nursing home care costs $10,000 a month, which is not unusual around here, Medicaid may delay her eligibility for 5 months because $50,000 divided by 10,000 is 5 months. That's the penalty period. It doesn't go away even if Martha needs care urgently. She'll just have to pay out of pocket for those 5 months. And after that, she may be eligible for Medicaid for them to step in and cover her long-term care and expenses. So here's another example. Selling assets, houses, cars, whatever it is, for less than fair market value and not at arm's length. Well, what does that mean? That means you're probably related to the person that you sold it to, and maybe you gave them a sweet deal, right? Because you like them, you love them. Seems like the right thing to do. So let's say Tom, a 75-year-old man, owns a cabin. There's a lot of those around here, right? And it's valued at $200,000. His health is deteriorating, and so he anticipates needing long-term care in the future. Tom wants to make sure his family keeps the cabin. They have so many great memories there. So he decides to sell it to his niece, Rachel, for $50,000. That's way below the actual market value. And that's not a problem if he doesn't want to apply for Medicaid benefits, but at the time of the sale, Tom believes this is a smart move to keep the cabin in the family while also reducing his total assets. Medicaid views this as a gift, and even though he sold the property, since he didn't receive the full market value, Medicaid will consider this a below-market sale and a sale that was not at arm's length, and it will count it as a transfer of assets with a penalty. Well, and because this transaction occurred within the 5 years, there will be a penalty imposed based on the value of the gift, which is the difference between the market value of the cabin, right, $200,000, and the sales price, $50,000. So that's $150,000. If the nursing home costs $10,000 a month, Medicaid's going to do the math and impose a 15-month penalty, $150,000 over 10 months, $10,000 over 15 months, I should say. This is the penalty period. Tom will not be eligible for Medicaid benefits and would have to cover the full cost of his care on his own. Here's another one, paying off debts or giving gifts right before entering care. Let's imagine that Betty, a 79-year-old woman with some savings, decides to pay off the mortgages and loans of her children a few months before she enters a nursing home. That's a nice thing to do, right? Who wouldn't like that? Well, over the course of 6 months, she writes checks totaling $60,000 to her children to help them out. Betty's children appreciate it, like I said, but when Betty applies for Medicaid a few months later, those transfers are going to be problematic. Medicaid will consider the payments gifts, even though they were made in good faith. It doesn't matter. Since the transfers occurred within the last 5 years, those gifts are going to trigger a penalty period. So if the nursing home, again, costs $10,000 a month, Betty could face a 6-month penalty. She'd have to pay $60,000 out of pocket. Before, like I said, before Medicaid would even step in. So, as you can see, the 5-year look-back period is incredibly important when it comes to Medicaid eligibility. And even if the transfer of assets seems like a good idea at the time, whether it's transferring a home to a child, gifting money to grandchildren, or selling property below market value, Just know it could result in a penalty period that delays any potential eligibility for Medicaid benefits. Well, what can you do about it? I have a few ideas about that, and we'll talk about that when we come back. Welcome back to Boomer Time. Nancy Cogar here, and we are talking Medicaid and the 5-year look back. I get lots of questions on it, and we just talked about a lot of the issues that come up, and sometimes you don't realize it. Lots of times, right? Well, I said I wanted to talk about a few strategies that may help you plan ahead and actually protect assets while still meeting Medicaid's eligibility criteria. Now, remember, I have to say this with a caveat that it's not just about assets, it's also about income. So you'd have to factor those things in here as well. But it's important to note, really, that not everyone's going to qualify for Medicaid ever because it's income based. And there are some strict guidelines on transfers, as I've explained, and the amount of income you can have in order to qualify. So that being said, even if you do qualify, you will have to find care in a nursing home that accepts Medicaid. Wait a second, what did I say? This is a surprise that comes up often, okay? So listen to me when I say, even if you do qualify for Medicaid, for TennCare, you can't go wherever you want. If you're going into a nursing home, you have to find a nursing home that accepts TennCare, Medicaid. Not all of them do. Did you know that? That not all nursing homes have what they call TennCare or Medicaid beds. That's a whole nother issue, but important to mention. Okay? But I do want to talk about some estate planning strategies, that might work for you if you're thinking nursing home and Medicaid requests are in your future. I always say, of course, plan for another option and another option and maybe even another option and make nursing home care the last option. So these strategies might help you with Medicaid eligibility, and I want to go over these one at a time. With all that, I'm telling you, it's not as simple as this in front, okay? So first, there's something called a Medicaid Asset Protection Trust, an MAPT. It's one way to avoid the penalties associated with the 5-year look back. So what you do is you set up this trust, and it's an irrevocable trust that is specifically designed to protect assets like your home, savings, all of that from Medicaid's asset tests. And then it would still allow the individual to qualify for long-term care. Well, how does that work? Well, let's say Susan, okay, another example, 70-year-old woman wants to protect her $300,000 home from being counted, which ironically would be exempt on the front end, but they would have recovery on the back end. I'll talk about that probably in another episode because this is complex stuff. But she wants to put it somewhere that she can protect it, both on the front end and the back end, from Medicaid. So with the help of an elder law attorney, Susan sets up one of these Medicaid asset protection trusts, and she transfers the house into the trust by deed. So now the house is owned by the trust or the trustee and not Susan. Susan isn't the trustee. The beauty of this kind of trust is that after 5 years, Susan will no longer be penalized by Medicaid for the transfers, and she will still be able to apply for long-term care benefits. Okay, well, it's important to note that once those assets are transferred into that trust, they are no longer considered part of an individual's estate. And they can't be accessed by that individual. You've got the third party who needs to manage those assets moving forward. So this can be a great way to protect your home or other assets, but it requires advanced planning. And it's an irrevocable trust. So once you create it, You're done. There's something also called a Miller Trust. So if your aging parent's income exceeds Medicaid's limit and all they have is income, a Miller Trust can be a helpful tool. It's known as a Qualified Income Trust, or a QIT. It's used to help individuals whose income is too high to qualify for Medicaid. Let's say someone earns $5,000 a month and the limit is 2901. Okay, that's too high. Let's take George, who's a 75-year-old man, and he's a little bit lower than that, but still above the limit. He's got $3,500 combined from his pension and Social Security. That's what they're going to look at every month. The Medicaid income level in his state is $2,500. So George wouldn't qualify, right, based on that calculation because his income is too high. However, if George sets up a Miller Trust and deposits his income into that trust each month, Medicaid will consider only the amount in the trust when determining eligibility and not his entire income. So it's as if he's contributing the overage to the care. That works. This allows George to qualify for Medicaid while still keeping his income protected in the trust to a certain extent. The funds in the Miller Trust, however, can be used to pay for his care or other qualified expenses, right? He can't spend them freely, though. It doesn't allow for the total elimination of recovery either based on George's death, because TennCare still has a responsibility, or mandate rather, to recover any benefits that are paid out for someone. That's why you hear in probate that TennCare can set aside transfer of a house and a will, something like that, and sell it to pay for those expenses. That's part of it. Well, here's another strategy, and this is the one I see more often than not. So, revocable living trusts. This is a strategy that may appeal and does appeal to individuals who want to retain more control over their assets. The revocable living trust. This trust is really useful with estate planning, and it allows for you to keep control of your property while it's in the trust and helps you to plan for the future. So in states where a residence, a home, is exempt for Medicaid qualifications, like here in Tennessee, a revocable living trust could be an attractive option. So let's say Helen, who's a 72-year-old woman, owns a home worth $250,000. She lives in a state where the primary residence is not counted as an asset for Medicaid eligibility purposes. That's because public policy, they don't want to make you homeless, right? They will recover against it after she dies. So on the front end, though, Helen can create a revocable living trust, transferring her home into this. This allows her to retain control over the property as trustee during her lifetime. She can still sell it, she can refinance it, she can live in it, she can do as she pleases, but all at the same time, it'll be protected from recovery, okay? And it's still an exempt asset. So if she needs help with long-term care, it's a good strategy. If Helen lives in a state where the residence is subject to recovery, as I mentioned, that means Medicaid can recover the cost of her care after her death through probate. Well, here's the really good thing. The revocable living trust may not provide the same level of protection as a Medicaid asset protection trust, but revocable trusts don't have to be probated. So you're avoiding having to probate it and expose it to potential creditors by that planning strategy. So even with that kind of limitation, the revocable trust can still be great as an option for individuals who want more flexibility and control over their assets while avoiding the complex rules of Medicaid asset protection trusts. So in summary, we've talked about a lot of stuff here, guys. The 5-year look back is something you need to keep in mind when you're helping your aging parent or loved one prepare for possible nursing home care. The best strategy, of course, is to plan ahead, consult with a professional, and make sure all your financial transactions are done in accordance with the rules to avoid those potential penalties. If you're concerned about Medicaid eligibility, you might consider the strategies like a Medicaid Asset Protection Trust or Miller Trust at the time that admission would take place to protect those assets and still qualify for potential benefits. And if you prefer to retain control over your assets, I find a Revocable Living Trust may be a great option. Just be sure to understand how it works in your state. Okay, here in my area, you can reach out to me and schedule a strategy session where we can work on your personalized estate plan, care plan. And once that's in place for you, so it will meet your specific needs. Well, thanks for tuning in, guys. And please take care of yourself and your loved ones. I hope you continue to watch Boomer Time as we talk about these tough issues. And remember to follow us on YouTube. Be a subscriber so you don't miss any of these in the future. And if you want to schedule a strategy session, you can contact me at my website, which is nancycogar.com. Well, that's it for today, but I'll see you next time, okay? Bye-bye.